Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, everybody. Oh my god. I need to get like Creed and get a good button for me to hit when I need to. Hi, everybody. I hope everybody is doing good today. It's Saturday, right? Is that right? The 6th day of the week. You like the curls? I just did this. I did this for you guys. A little practice here, a little practice there. Thank you guys so much for being here tonight. I appreciate each and every one of you. We are on my Wednesday, the middle of the week. And you know what Dyson Airwrap, no. Conair cheap thing. My hair won't work in a Dyson Airwrap, Brooklyn. My sister's a hairdresser, as we remember. And we just have really straight hair. So a Dyson hair wrap is better for people that have a little bit of texture to their hair, I think. It would never be worth my money. Let's just put it that way. Never worth it. Never. Anyways. No, I did this with a really shitty, I know it's $600. She has one. Does she have the air wrap? She has it. She's a hairdresser, so she knows all these things, but she's, so if I ever need one, I could use hers, but I did this myself with an $18 curling iron, so, you know, I'm a little old school, if you will. Anyways, let's travel by Floozy Powder. There we go. That's a bit better. What a day. What a few days. Oh my god, you guys. It's been a lot. I never blow dry my hair, and I actually almost never heat treat it. If I curl it, it's for you guys. You see that. So the reality for me is that I don't do a lot of heat treatment on my hair. I know that's bad for your hair, and I don't do that very often. So my sister's always amazed. She's like, your hair is very healthy, and that's because I do nothing to it. Turns out that's pretty good. I know that's not realistic for everybody, but anyways, we're going off to Judge Ricky first in
LAW,
Kansas.
a minor child buying through her next friend and father, Ryan Wyndham,
What?
and Brittany Runyon. Case number 2025 DM 408. Counsel, beginning with the petitioning party, Ryan. Counsel, announce appearances for the record, please.
Thank you, Your Honor. May it please the court, Riley Broyles appears on behalf of petitioner Ryan Wyndham, who appears via Zoom.
Brian Kuhn on behalf of Brittany Runyon, who appears in my office via Zoom.
This matter comes before the court at this time, I think, for the first time. There was an agreed upon order for mediation approved by this court earlier. Subsequent to that, there's been an emergency motion filed for change of custody and modification of parenting time. Counsel, I want to ask first, is there any other case from any other court that has an impact on custody or visitation rights here?
No, Your Honor, not to my knowledge.
All right.
His other daughter.
For future knowledge, can you guys please remind me to take some cute pictures of myself right away? Because you and I both know that as this hour progresses, or however long we're here, my hair will go flatter and flatter. My makeup will be rubbed off. Hi, I talk about Bruno. How you doing? I was thinking about your day drinking yesterday. Anyways, yeah. Yeah, right. tell you like yoga pants. Oh, but I will take a picture.
Second of all, I think council verified that there is no existing order in this case.
That's correct, Your Honor. I did file a motion to set temporary orders along with my petition, but that has not been heard yet either.
All right. So what has the de facto custody arrangement been, Ms. Broyles?
Thank you, Your Honor. The de facto, according to my client, up until New Year's Eve was week on, week off, with the exchanges occurring on Fridays. And then after this emergency motion was filed is when Ms. Runyon began withholding parenting time. And my client did see the child for about 4 hours this past Saturday, but otherwise has not had parenting time since New Year's Eve.
All right, Mr. Kuhn, are you and your client still pursuing this emergency motion at this time?
Yes, we are, Your Honor.
What is the emergency?
The petitioner has provided alcohol and marijuana to his underage girlfriend. I guess for marijuana, there is no age, of course.
Oh my god, I'm choking on my own marijuana. Holy shit. What? Oh my god. Don't throw your back out, Bruno. Don't you have like a 19-year-old and like a 22-year-old? Also, is the problem not the underage girlfriend? Did she just say that the dad has an underage girlfriend? Why aren't we leading with that? I'm not really worried about how the weed and the booze. Let's talk about that. I gotta go back. Oh my god. What the fuck is happening? Oh, once again, didn't watch this first.
All right, Mr. Kuhn, are you and your client still pursuing this emergency motion at this time?
Yes, we are, Your Honor.
What is the emergency?
The petitioner has provided alcohol and marijuana to his underage girlfriend. I guess for marijuana, there is no age, of course. This has been disconcerting to the respondent. In addition, they've had some violent incidents as well, with him pushing things into her and screaming and yelling. Some behavior that is into the range of unreasonable behavior. Because of the drugs and the alcohol that have been provided to his girlfriend, we are seeking an emergency order giving custody to the respondent until such time drug and alcohol and anger management can be undergone.
All right. The information regarding marijuana use in his home comes from where?
It comes from the girl that he was seeing.
It was third-party information from the girl that he was seeing, Miss Liliana Kluth.
AKA
In
hearsay.
other words, hearsay.
And then
Yes, Your Honor.
the oldest.
Yeah, it is hearsay, ma'am. You don't understand what hearsay is. We don't care if you saw her say it. It's fucking hearsay.
Right. Are there any other grounds that you're relying upon to seek emergency relief pursuant to your motion?
So he's
Where's the witness? Where's the police report? I have so many questions. I'm being serious. At this point, it is so ridiculous. Brian? Sir? Sir? What? Brian, this is not the right move. Jesus Christ. Yeah, what is underage? Why are the questions not being asked? At what age? Why are you talking to her? All the questions. This would have been easier to do, ma'am, if you just called the police, ma'am. But it strikes me that I may have been getting fired up over here. And in reality, why wouldn't you be calling the police if it was as bad as it is? Is it because it's not illegal? It's not bad? I don't know. Underage implies underage. If she's 19 or 18, oh, she's putting a little loophole in there. I'm not going to be impressed with that. That's not what I consider underage. Sorry. You can go by Canadian legal age 18. That's what we do here. It's like metric.
He left them all together, and then she also
And-
drink alcohol.
The other daughters as well have been watching him drink unreasonably, the older daughters as well.
And
And
this is
that's
his
all.
daughter from another relationship?
Yes, Your Honor.
Okay. And apparently, based on
Also
information
hearsay.
you sent to the court, the Sedgwick County District Court has taken action in that case?
It's my understanding, yes.
All right. Ms. Royals, what would your response be?
Yes, Your Honor, thank you. We did file a formal response with the court in response to this emergency motion. But just to kind of paraphrase, on the issue or the allegation that my client provided Ms. Cluth with alcohol and marijuana, my client categorically denies that. But as the court noted, that is entirely hearsay. They did not provide any sort of affidavit of Ms. Cluth. They have not produced her for testimony today, to my knowledge. So any allegations, which frankly, the majority of their allegations in this emergency motion are hearsay allegations from Ms. Cluth, who is clearly a very disgruntled, troubled young woman. And the fact that she's not here to testify, that I can't cross-examine her, obviously causes huge issues. But however, Your Honor, I think it's important to note, frankly, even if he did provide this, which he, again, categorically denies, that has nothing to do with the party's minor child. Lyric, who is 4 years old. They're not alleging any allegations of harm coming to this child. And the child, his other child from a previous relationship, is a 9-year-old. So I would frankly take, again, hearsay, but a lot of grains of salt with a statement from a 9-year-old, who again, we don't know how this all came up. So any allegations from the 9-year-old who's providing information to, I'm assuming, to her mom, who's in cahoots with Miss Runyon, and I think Liliana seems to be in cahoots, or all these ex-girlfriends are in cahoots with each other to, gang up against my client.
First of all, did you say
I mean,
gay up? Secondly, cahoots. We don't usually get one cahoot in a court hearing, let alone 3 cahoots. That's a lot of cahooting. Everybody in cahoots within one another. The more complicated and the more people in collusion together, the less likely it's true, and the more likely he's just a dick, allegedly. I haven't even heard most of it. If she's 18 or 19, I'm not really even worried about him giving her weed or booze. Technical violation. A technical penalty.
Miss Runyon, and I think Liliana seems to be in cahoots, or all these ex-girlfriends are in cahoots with each other to, gang up against my client. I mean, procedurally, there's an evidentiary wise, there's no basis to grant any sort of emergency relief here. There are no allegations of imminent harm to this child, this 4-year-old child. In their motion or from counsel's statements, they have not alleged any harm to this child. So we're asking the court to adopt the de facto arrangement, and the court is allowed to do that pursuant to KSA 23-2224, that allows the court to make orders to confirm the existing de facto custody of the child. And so that's what we're asking the court to do today, because their motion does not rise to the level of an emergency to warrant a modification of the de facto parenting time. And I would also point out to the court that in their motion, they're requesting the modification of his parenting time, of dad's parenting time, be every other weekend, 6 p.m. on Friday to 7 p.m. on Sunday. And frankly, Your Honor, if you're so worried for your child's safety, you give him a full every other weekend. I think, frankly, all this motion is a way to try to get primary residential custody of this child, and probably some child support. Because if you're so afraid for your child's life, you're asking for every other weekend for dad. On a weekend, if you're worried about drugs and alcohol, assuming that would be the time when that would most likely occur. So it's extremely disingenuous to file this emergency motion on the eve of this hearing date that we have. And I think the court has previously taken evidence between these parties on a PFS a few weeks ago, and Ms. Runyon has filed 2 PFAs that were summarily denied. So frankly, for my position, we're dealing with the girl who cried wolf here. She filed 3 PFAs, those didn't work, so let's try this emergency motion and see if that works. But there's just not enough here to warrant a modification of the de facto. This is just frankly a ploy to get primary, in my opinion. So we're asking the court to confirm the de facto today.
Mr. Kuhn, any reply argument that you desire to make?
The respondent did file a police report after the petitioner shoved a shopping cart into her stomach at the petitioner's home while the respondent was picking up the minor child.
Okay, first red flag. Who has a shopping cart at their home? I have questions about that. What is happening? Why would you have a shopping cart? The only people in my town that have shopping carts are grocery stores and people that steal them from grocery stores that are homeless. It would be an extreme red flag if somebody had a grocery cart at their disposal in their yard. And if he's alleging it's some little tiny bag granny cart, no, then you can't say shopping cart. No. Also, I know there's a debate on what you call those. Anyways.
There's a Wichita Police Department case number that is firsthand, and that did occur directly to my client.
Well,
And while the minor
Mr.
child,
Wyndham has a shopping cart at his home?
it was a toy shopping cart.
a toy shopping cart.
Oh. One made out
You
of
dumb
plastic?
bitch.
Yes, my
You
understanding.
fucking dumb bitch. Oh my god. Brian, did you ask her about the shopping cart like the judge did, like I did? Did you ask? You look caught out right now, Brian. You look fucking caught out. Look at his face. I should have asked about that shopping cart. Courtney? Oh my god. That's so funny to me. Look at the judge is like, you dumbass. Felony toy shopping cart assault. The plastic almost broke. It was bending. You understand, Judge? Bent plastic. No.
Department case number that is firsthand, and that did occur directly to my client.
Well,
And while the minor
Mr.
child,
Wyndham has a shopping cart at his home?
it was a toy shopping cart.
a toy shopping cart.
Oh. One made out of plastic?
Yes, my understanding.
And then he rolled over on her, intoxicated, 26th, and the 27th, they got the call.
And on the 26th, he had rolled over on the minor child intoxicated, and on the 27th was when she received the call from Liliana.
Asking him to pick clear cut because they were all afraid of him hiding.
Hearsay. Child hearsay. Child hearsay.
Okay. All right, anything else you want to say about that, Ms. Broyles?
I guess regarding the allegation of the rolling over, that's not in their motion, which they say occurred on the 27th, I think is what I heard. And this was filed on the 31st. So presumably if that happened and it was reported to Ms. Runyon, it would have been included in their motion, and it wasn't. But again, unless Ms. Runyon was in bed with Mr. Wyndham when this happened, I'm assuming she got this information from Ms. Kluth, which again would be hearsay allegations. And Ms. Kluth is not here to testify. I'm not able to cross-examine her. They had every opportunity to produce her for testimony, and they have not done so. So any allegations that Ms. Kluth would like to bring, or any that she witnessed personally, should be disregarded by this court.
Ms. Broyles, what is the current status of the mediation that was ordered by the court?
Yes, Your Honor, that was originally scheduled for last Friday, but the mediator had a funeral, and so she had to reschedule it, and they are currently scheduled for mediation this Thursday.
Oh, all right. Who is the mediator?
Sarah Spar.
Okay.
And Your Honor, the police report was included as number 8 on my motion. If Ms. Broyles wants to check number 8.
Well, yeah, I guess I should, I guess I can clarify my point. The rolling over incident, where he was intoxicated and rolled over on the child, if that's what they're saying, was not included in the motion. Number 8, I was aware that it says that about the shopping cart incident, but again, that has nothing to do with this minor child. So I don't think that gives any additional basis to restrict his parenting time from the de facto.
Are these exhibits individually marked and numbered?
They're not her
I'm trying to
exhibits.
scroll
Again,
on the
Brian.
screen here, counsel, so.
Brian.
I apologize. They don't appear to be. I apologize.
And somewhere in
As-
here, there's a Wichita police report.
Yes, towards the end, I believe.
As per my last email, Brian.
Sure, and I did receive counsel's exhibits.
I want to point something out. The average person maybe doesn't really see lawyers be lawyers very often, but we do, weirdly enough. We watch a lot of courtrooms that, in fact, more than most lawyers. I've talked about this before, how in reality, after doing this channel for many, many years now and watching live court alongside that for many years, I have been in the courtrooms a lot more than a lot of lawyers. Now, I don't know the law. No, not at all. But I know a lot of courtrooms very well, nuances, etc. And what else you can tell very quickly is when a lawyer is prepared versus not. When you pay a lawyer, you pay them to prepare. You pay them to not look like fucking Brian. Okay? That's the reality.
He submitted last night around 4, I think it was around 4:50, and I did have a chance to review those. There were amended exhibits that were submitted around 2:30 that I briefly was able to glance at, but I've been in a meeting with my client since 2, so I didn't have a chance to fully review those. And frankly, they're hard to read. They're grayed out, and all of these police reports, Your Honor, they're highly redacted. I mean, obviously we have foundational issues. Where did these come from? And again, additional hearsay issues. But the way these are redacted is very suspect. There's huge portions of it that are redacted from the ones that I was able to review. That I don't know, did they redact the things they didn't like about them that weren't helpful for their case? So I would ask the court to disregard any of the police reports for lacking evidence or lacking foundation and for hearsay.
In court.
Hmm.
And these are that from the police station in there.
I trust since this was filed as a paternity action, that there's no dispute that Ryan Wyndham is the natural father of LAW, a minor child.
There's no dispute.
No dispute, Your Honor.
All right, we'll first make that finding that he is the father
Does he dispute?
and has the rights and responsibilities connected with being a father to this child. The court has read and considered the emergency motion for change of custody and modification of parenting time. Court has also considered the response that was filed in this case. Court has also had an opportunity to at least scan or look through the documents that were just provided to the court earlier this afternoon. The court shares the concerns about the redaction and, in fact, the pertinence of some of this police information to this case. This court does not feel bound by any determination a separate court has made regarding a child belonging to one of these parties. The court simply does not see that there are emergency circumstances here that would warrant some dramatic change in parenting rights in this case. At most, in the view of the court, what's alleged is some questionable decision-making and perhaps even a suggested lack of morality. Nevertheless, there's no verification of some of these incidents, which are deemed to be serious. And the court's not inclined to interfere with the constitutional right of Ryan Wyndham to parent his child. With that said, the court's going to enter an order at this point that neither party is to drink alcohol during their parenting periods with the child. Furthermore, under no circumstances does this court authorize either party to use marijuana. That's an illegal drug in Kansas, well accepted in other states, but not in this state, and certainly not by this court. So that will be a specific order that the court will make. Since the parties have apparently had a de facto custody arrangement, the court will adopt it. The court will temporarily order joint legal custody with a week-to-week shared custody plan, exchanging what time on Friday, Ms. Broyles?
Week to week. Wow. That's interesting. They don't do that in Texas a lot.
Is there a consistent time and place?
It was usually around like 3 p.m.
Around 3 o'clock, my client says.
Okay, I want to hear from the mother on this.
He drops her off at my house at 7:30 every morning on Friday when it's his day. His mom has never watched her on Friday, but she does watch her on Tuesdays for me. And his parents were supervising his contact with her because even they were concerned about his mental state.
So let's just make a time.
I just want to say that they even, but I have no problem with him having her, but it's 7:30 in the morning on Friday is when he drops her off.
Your Honor, 7:30 in the morning on Friday is fine.
All right. Ms. Broyles, I'm going to ask you to draft an initial order in this case.
Did he say week on
Since
week off?
you represent the filing party, we need to have a finding of paternity and for this court to make initial orders in the case. The court will reiterate its order for mediation in this case. There are some issues here that these parties need to work through and they need to discuss. And I think that the mediation with Ms. Farr would be very helpful and perhaps parties being able to express their concerns and to try to reach appropriate agreements regarding the best interest of their minor child. I also want to specifically note here that even though there are some areas of concern here, it does not appear that at any time this 4-year-old child who's the subject of this case was ever in imminent danger. This rollover incident, let's just say, Mr. Wyndham, these things happen. You need to make sure, though, that at all times you conduct yourself in a way to keep your child safe and be ever mindful that you're a lot bigger than her. And even rolling on her could cause injury. So be careful. That's just what I'm asking you to do.
That's a weird admonition.
All right.
You're a big man.
Regarding initial orders,
You gotta
in the
be
case.
careful where you
Ms.
roll.
Broyles,
You understand? You're fat.
From your perspective, is there anything else that needs to be addressed at this time?
Your Honor, the only other issue would be the issue of child support. We did file a DRA and a proposed child support worksheet. I don't see that Ms. Runyon has filed a DRA and we haven't exchanged income information. So I think between counsel and I, we probably can do a agreed child support worksheet. We would just need to exchange income information and confer regarding child support.
What is your proposed effective date for the child support order?
Your Honor, we filed our motion on October 24th. So November 1, I think would be appropriate.
Mr. Kuhn, would you like to be heard on the effective date of child support in this case?
That seems reasonable, Your Honor.
Very well. November 1 will be the effective date.
Community.
And counsel, I would just ask you to immediately exchange any pertinent information necessary to do the child support worksheet so that there's no further delay. This case has been pending since October. So the sooner we get an appropriate child support order in effect, it'll be based on a shared residential custody schedule. But the better, I think things are if we get that order operative and going.
Your Honor, if
Yes,
the,
Mr. Kuhn.
if the exchange of the child could occur at the police station, that would be greatly appreciated.
Why is that necessary?
My client is in fear of her safety.
There's been
Your
several.
Honor, I would object to that. I mean, the parties have been exchanging fine up until the cessation of his parenting time by Ms. Runyon. And I think a lot of times, my client's parents help facilitate the exchanges. But she's filed 2 PFAs and they've both been found, they were both dismissed. To say she's in fear of her life, I don't think there's enough found by this court and by Judge Hart that she didn't have enough for a PFA. So I don't think she has enough for, and I think that would be traumatic for the child to exchange at the police station. And I don't see what benefit that would have.
Okay. Mr. Wyndham would otherwise be dropping off and apparently picking up at the mother's house. Is that right?
We've been meeting sometimes at Dylan's. Sometimes he'll drop her off at my house. I'm okay if he comes to my house to do it because I have cameras, but I'm not comfortable going to his. Last time my daughter was there when he shoved me, there's even a police report
Your Honor,
from his
Your
girlfriend.
Honor,
Okay. All right. With that said, all right. Apparently the mother is agreeable that the drop off can take place at her residence, which makes all kinds of sense. Where does the father live?
Yeah, I guess so.
Augusta, he's fine with exchanges occurring at mother's house. That's fine.
All right. So he'll do his pickups there as well. All right.
I feel comfortable with that.
Mr. Wyndham, you can have another responsible adult person in the car with you when you do your pickup, but they're to not interfere in any way with your business with the mother of the child, okay?
Yes, Your Honor.
I don't know.
Okay. All right.
And that's it.
Preferably a family member of some kind if they're available. If not, you're certainly authorized to do it on your own. Okay. So the next exchange will be Friday morning? Is that what's contemplated here?
That would be fine, Your Honor.
All right.
Well, since his parents have her right now, will he just go pick her up from them since it's supposed to be his week with him?
Currently, my understanding is the child is with the petitioner, and so
No, his
Start
parents.
fresh on Friday.
or his
right?
parents, excuse me.
Your
So
Honor,
it'd be
my,
picking up from the parents.
Your Honor, my client's position, I mean, it's Tuesday evening. He would like his full week. I think it makes the most sense mom can have this week. We start fresh on Friday with him picking up from mom's house at 7:30 and then we alternate from there. So I
Court's
apologize.
inclined to agree.
Okay.
Remember at all times, parents, that this is all intended to be in the best interest of your minor child. So I would ask you to participate in mediation in good faith. Try to work with each other. You know your child better than anyone else in the world to try to work out the best possible plan for her long-term welfare. Good luck in that regard. Again, Ms. Broyles, if you'll draft an appropriate journal entry of paternity and documenting the temporary orders which have been implemented by the court here today.
Yes, Your Honor, I will do that.
Do you need any further clarification regarding those orders?
I do not believe so. Thank you.
Mr. Kuhn, do you?
No, Your Honor.
All right. Then if there's nothing further at this time, the Wyndham and Runyon matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Your Honor.
This meeting may be ended for all, but not for you. We're gonna watch some more court. Don't you worry. Oh,
Ricardo Montalvo.
Ricardo.
All right, hold on a second. All right, in the matter
It's a bit more
of
nasally
telling Mel,
up here in Michigan. Up in Michigan, the you hear the Hi Adam, you're late. But you're here. And that's okay, my dear. What's with my curls? I do them for you guys. Actually, I do have a hot date tonight. Hopefully. Let's see if I get stood up.
Butler versus Ricardo Montalvo, file number 1994-16285 DP. Sir, that matter has been dismissed. Thank you.
Thank you, Your Honor. Have a good morning.
You too.
Oh, we got the big D right away. We got that D. That's the kind of D I like. A big dismissal. Ooh, put that big D in the chat. Woo. Oh my gosh. Right off the bat, we love a dismissal. A 1994 dismissal case. Woo. There's no rumor about that, Brooklyn. There's no rumor about that. I'm going out on the town by myself. Don't you worry. I entertain myself all the time. And honestly, my big D excitement comes from the denials or dismissals.
Okay, what is your name?
Armando
Armando what?
Damon.
All right, in the matter of Jersey Garza versus Armando Damon, file number 21-49014 DC. It's been adjourned to March 9. So Mr. Damon, go downstairs to front of the court and make sure your caseworker has your updated phone number. They're required to call you the Friday before to let you know if there's been an adjournment or a cancellation. Who's your caseworker?
Kelly.
All right, so stop down there and make sure to update your phone number because they will call you and let you know so you don't have to come in, all right?
Thank you, I appreciate it.
You're welcome. All right, the gentleman in the back,
The gentleman
What's
in
your
the
name?
back,
Ladd.
say it again.
Mark Ladd.
Mark. It's always a Mark.
Okay, why don't you come on up in the matter of Janet Ladd versus Mark Ladd, file number 2010-34945 DM. Let me get your paperwork. All right, okay, so this
Right. If you
is,
want to come party with me tonight,
gonna
ladies
rip-
and gentlemen, you are invited. Let's go out together. Come to my island and let's have some fun. I'll take you out. Yeah, come on down.
marriages.
Yep.
No, let me see, 2010, so. Yep, so, Mr. Ladd, you have a monthly order of $397 a month of child support. The original show cause we were here for was October 20th of 25. At that time, the arrearage was $8,564.55. As of today's date, it's gone up about $1,200. This is your third show cause. So we did receive a payment of $1,486 back on March 25 of 2024. The last time we were here on December 1, we adjourned it to today for you to have proof of disability work paperwork turned in. You did turn in a letter from the Social Security Administration saying that you have been found to meet the medical requirements for disability benefits. So, Mr. Anderson, at this point, you know, Mr. Ladd, there'll be a lump sum payment. Yeah, he's.
I didn't see him up there.
No, it's okay. There will be a lump sum payment paid out to you, and we do expect it to be applied to this. Do you understand that?
Yes.
Okay, and even though you're on disability, you still gotta make the payments. They'll just be less, okay? So it doesn't wash it out.
No, I didn't expect it to. The intake meeting is in 2 days, Wednesday.
Good,
this
good.
Wednesday morning, so I really don't know nothing now.
And then if it's disability SSD and not SSI, Mr. Anderson, will that also make a payment to the child?
Yes.
Okay, so that'll help you out too. So make sure you stay in contact with Mr. Anderson. I'm gonna put this out to March 9, Mr. Ladd, just to kind of track it and make sure everything goes as it's supposed to, okay?
Sounds good.
All right, so we'll see you back March 9 at 8 AM. Thank you, Mr. Ladd.
Hey, Space Pander, how you doing? You have a cabin with a boat.
All right,
I love that.
so,
Does it have a boat?
Lady in back, what's your name?
Jamie Smith.
Jenny Smith?
Or why don't you come on out?
She sounds Scottish. Jenny Smith. it's probably Janae Smith.
Move that microphone. Okay. This is in the matter of Jamie Lynn Smith versus Dustin Dwayne Sharp, file number 2007-31555DS. This is an arrearages only file. We were here on October 27th of 25. At that time, the arrearage was $2,029. Today it's $2,050. That must be fees. This is your third show cause. All right. So ma'am, we just need this paid off, so we don't have to keep bringing you back in. So are you able?
Ma'am. Oh my God. Amid the Michigan ma'am is actually what I fashion my ma'am after. You'll notice I do a really good one. Ma'am. And I just realized I might be copying Judge Anzalone every time I say that. Ma'am. Oh my God. Ma'am, we just need our money. Ma'am.
Is your third show cause. All right. So ma'am, we just need this paid off, so we don't have to keep bringing you back in. So are you able to make a monthly payment on this?
I can start making payments.
Okay, so what can you make? Are you working?
No, I'm not. I'm a stay-at-home mom. But my fiance's told me that he'd help me get it paid off.
Okay,
I'm a
so
stay-at-home
even if you're a
mom.
stay-at-home mom, you still gotta pay your child
Right.
support, right? So if you have to get a part-time job, you do it. So I would like $100 a month.
Probably make
I
that.
would like
Okay.
$1,000.
All right, so I'm gonna order that you pay $100 a month, and that'll start in January. So I need a payment this month.
Okay.
I'm gonna set this out to March 9 to monitor that you're making payments. And if you can just make that like by the second week of the month or something like that, all right?
Okay.
All right,
By
thank
the
you.
second week
March
of the
9 will
month.
come back. Thank you.
Ma'am. Thank you, ma'am.
And sir, what is your name?
Sir.
Okay, let me find
Sir.
you. All right,
Sir.
come on up. So this is in the matter of Shalisa McAnally versus Michael McAnally, file number
What a beard. Holy
2013.
moly. Do you remember we had a run for a little while of beards, like epic beards? That is an epic beard. Look at that. Glorious. That looks like I mean, how is it white? But the hair, I mean, can we see the entrance one more time, sir? Come on down. Your beard is the next contestant.
All right, come on up. So this is in the matter of Shalisa McAnally versus Michael McAnally, file number 2013-39382DM. So Mr. McAnally, we are here on long adjourned show cause. So it looks like the original show cause was February 12th of 24, almost 2 years ago. At that time, your rearage was $9,389. Your rearage today is $11,482.98. You had a monthly charge of $230. This is like your sixth show cause. You paid $10 on November 5 of 25. It says you're employed by Liberty Mutual Insurance Company. Is that correct?
That's my disability.
Okay, and then you did turn in paperwork from Cooper Bender saying they were working on your workers' comp claim, correct?
Yes, ma'am.
All right, that was back in September. So what's going on now?
The disabilities postponed. They went to the hearing on the 4th. And when I called the lawyer to make sure, because I don't have to be there, he does all that for me. He said that unfortunately it has been adjourned.
To when?
He didn't give me a date. He just said that it's gonna be a couple months. That's not good for me or my landlord. My landlord's
No?
getting the majority of my money and you're getting the rest, you know what I'm saying?
Okay. All right, you did provide documentation, so I'm gonna set this out to March 9. Mr. McAnally, you know, obviously apply what you can to it.
Yes, ma'am.
And then make sure that you keep Mr. Anderson updated on any, Mr. Anderson updated on any changes. All right, and we will see you back on March 9.
I did make $100 payment today.
Oh, excellent. Thank you. He does have a receipt, Mr. Anderson, for $100. Perfect.
Well, that's
Thank you.
very nice.
We're good.
Thank you.
Thank you.
He's trying.
Matter of Tiffany Aceves versus Dennis Hanshu, file number 2009-33817DS. That matter has been adjourned to February 23rd at 8 a.m. In the matter of Catherine Rink versus Michael Lewis, file number 2009-34541DP. That matter's been adjourned to, I think, March 9. I said Michael Lewis, right, Joanne? Okay.
Yes, Judge, you did.
And then Haley Vidales versus Ronald Walker, file number 2014-41077DP has been adjourned to March 2nd. Iona Folk versus Deanne Wilson, file number 20-47450DP has been adjourned to February 23rd. Let me let Miss, oh,
It's rapid fire court minute with Paisley.
all right, Mr. Walker, go ahead and, hi, good morning, Mr. Walker. So Mr. Walker.
Good morning.
Good morning. Your case has been adjourned to March 2nd. Who is your caseworker, Mr. Walker?
I don't know, Ms. Angelone. I was trying to figure that out right now. Also, I don't know who my caseworker is, though.
Okay, so Mr. Anderson, here's what I'm gonna do. I'm gonna put you in a breakout room real quick with Mr. Anderson for him to make sure they have an updated phone number. And then always
Yes,
make
ma'am.
sure your voicemail is empty because they are supposed to call and let you know when it's been adjourned, all right?
Yes, ma'am. I didn't know.
All right, they just have to have a good number.
Okay, I just wanted to make sure I didn't get a contempt because I'm at work right now, man.
No, so I'm gonna put you in a breakout room real quick. Give Mr. Anderson your updated phone number. There you go.
Yes,
then you're
ma'am.
all
Have a
set.
good weekend. Thank you.
You too. A good week. Thanks. Bye.
Peace out. Oh my God. Are we having a good weekend? Is everybody that Saturday is today having a good Saturday? I don't know what that sound was, Judge, but I hope you are. I ride everybody's Saturday high.
All right,
Friday
Mr.
high.
McQuiston, in the matter of Derek McQuiston versus Sarah McQuiston, file number 24-51427DM. Mr. McQuiston, this has been dismissed. So you are all set. Mr. McQuiston, make sure that your friend of the court caseworker has your updated phone number. Do you know who your caseworker is?
Patrick, I'm jealous.
I do not.
Let me look. Looks like it's Jeff Anderson. He's gonna pop back in a minute. And I'm gonna put you in a breakout room for you to give them an updated phone number. They're supposed to call the week, like the Friday before, to let you know if it's been dismissed or something like that. And that way you don't have to zoom in, okay?
Oh, okay.
Yep, and then just make sure your voicemail's set up. Surprisingly, a lot of people don't. All right, in the matter of Abigail Craig versus Michael Madrid, file number 20-47630DS. This is date and time set for a show cause. Mr. Madrid was ordered to appear. He's failed to do so. He's ordered to pay $342 a month. His arrearage as of today is $18,567. I will,
That's a lot of cruises.
he made a payment of $225 back on December 8th of 25. Is that the only payment? Well, I'm
Which cruise line?
gonna issue a bench warrant for his arrest.
Talk
For
to
failure
my
to
heart.
appear, and I will set bond in the amount of $2,500. All right, hold on just a second, Mr.
Oil
McQuiston, and we'll get Mr.
Caribbean.
Anderson back here.
Sounds like fun. I wish I was there. I hope you have a great time. Enjoy it. Do all the fun things. Try and find some spots on the ship that you didn't know existed. That's my favorite thing to do. Explore ships. Oh my God. I love it. I love it. Take me on a cruise, baby.
No, I'm
Take
bad.
me-
Like,
I
gotta
say work
Okay, Mr. Anderson, I have Mr. McQuiston. I'm also gonna put him in a breakout room with you. You're his caseworker, and that way you can get a valid email address from him.
Okay.
And, or phone number or email from him to notify in advance if he doesn't have to show up. And then Mr. McQuiston, when you're done, you can just disconnect and go on your way, all right?
All right. Thank you.
Thank you.
Mr. McQuiston says thank you, and we go back to the kitchen. Captain Snarky, you're back, but it's actually time for us to say goodnight. It's been a long day, a long week so far, not even close to over, but we will do it. We will. We will. I appreciate each and every one of you. Tomorrow is going to be a members only in the evening, probably 7. It depends. I don't know. I have to check. Sorry, I'm doing a lot of mental math and I'm not very good at it. Anyways, I'll let you guys know. I'll actually post it tonight once I figure it out, okay? But thank you so much for being here. Do me a favor. In the meantime, remember that I love you and I'm proud of you. And I will see you in the next video. Okay, bye. Bye.
Ways down and ready to ride.